For those who are joining us on a future recording for this afternoon Sunday session, we're going to have both Dr. Vernon Burton joining us and also view an interview with his Justice Deferred co-author, Armand Derfner, who again is a longtime civil and human rights champion in the legal system. So first, we're going to view an interview that I did with Mr. Derfner, where he talks a bit about the Reconstruction era amendments and their relationship to civil and voting rights in recent American history. So we're going to start with that first for our Sunday session. Hello, everyone. Welcome back to the Modjeska Simkins School of Human Rights. And today we are honored and fortunate to be able to interview Armand Derfner, one of the co-authors of the book Justice Deferred, Race and the Supreme Court. Mr. Derfner has also been a long-time practicing civil rights attorney who's been involved with a wide range of cases involving voting rights and civil rights throughout the South and across the country. And of course, in the Modjeska Simkins School of Human Rights, we all understand the importance of civil rights, voting rights, and human rights to our everyday lives. So Mr. Derfner, welcome back to our class.
Good to see you, Dr. Green.
And again, we're so fortunate to have you. And we're going to jump right into our conversation today because, of course, there's a lot going on with the Supreme Court, with race, with issues of voting and civil rights in America. But I actually want to start things first by talking about the book you co-wrote with Vernon Burton, another friend of the school, Justice Deferred, Race and the Supreme Court. If you don't mind, could you tell us a bit about what was it that pushed you and Dr. Burton to write the book Justice Deferred?
Well, Vernon Burton and I have known each other for now about 45 years. We got to know each other in 1980, right after the Supreme Court had taken a giant step backward by in something called a Mobile case, when they really made it a lot more difficult for people who were victimized by voting discrimination to prove that. The Supreme Court may set up new hurdles. And we've been talking about the issue since that time as the Supreme Court has gotten worse and worse. So even though we thought the Supreme Court was doing badly around 1980, that is nothing compared to what the court has done since that time and threatens to keep on doing if something doesn't change. And so we started talking about it, and we sort of went back to the beginning and tried to project it onto the present. And one of the things that we focused on was the notion that the Supreme Court has different images in different times. People, at least in my day, which is a little bit before most everybody else's, we thought of the Supreme Court as the protector of democracy, protects the right to vote, ended segregation, guarantees fair trials and free speech. But it turns out, as we looked at it, that really goes to a very short period in the court's history, from about the mid-1930s to the mid-1970s. That's 40 years out of 240 of the Supreme Court. And for the century and a half before that time, and for the half century since that time, the court has been really a drag on democracy, has been an institution that really has endangered our democracy. So we wanted to highlight how the Supreme Court has played different roles at different times.
Definitely. I think that's a really important point that a lot of our students are coming to understand more in the Modjeska Simkins School. And to kind of drill a bit deeper into this topic, I would like to talk specifically about the Reconstruction era amendments and their relationship to the Constitution and the Supreme Court. Of course, those are the 13th, 14th, and 15th Amendments. And many historians argue that these Reconstruction era amendments really helped to shape the Constitution as we know it in the 21st century. So could you talk a little bit about how those Reconstruction amendments are so important to the modern U.S. Constitution and debates about the U.S. Constitution taking place right now?
Okay, they really created a second constitution. Until the 13th, 14th, and 15th Amendments, which we sometimes call the Civil War Amendments or the Reconstruction Amendments, because they were all passed between 1865 and 1870. Before that time, for three-quarters of a century before that, the Constitution was basically a limitation on the federal government. Federal government didn't barely count for anything. The states were sovereign and supreme. Even the Bill of Rights didn't apply to the states. So if you had, the First Amendment said Congress couldn't regulate free speech. The states were free to do whatever they want to crash free speech under the federal Constitution. So the 13th, 14th, and 15th Amendments created a new relationship in which the federal government had real powers and the state governments had real limitations. And that was what the Constitution, what those amendments were supposed to do. Unfortunately, for a lot of reasons, it didn't really work out that way. And so for many years after those amendments were passed, really until about the 1930s, they didn't count for anything still. And the court was a leader in making sure that those amendments didn't matter at all. So it was only toward the middle of the 20th century, starting in the 30s and building up into the 50s and 60s, that the Reconstruction Amendments really began to make a difference. And unfortunately, since the 1970s, the court's been going out of its way to put the states back in control, not just in general, but for the bad things that the states do, and to make some real opinionated rulings on the Constitution, on the amendments. I'll just give you one example, which we talk about in the book. The court goes out of its way, this modern court, to say the Second Amendment is virtually limitless, the right to keep and bear arms, overturning 150 years worth of precedent that limited the Second Amendment to militias, to the state militia. The court likewise has taken the religious clause, the freedom of religion in the First Amendment, and used it to end the ban on establishment of religion. So when I was growing up, religion had a real place in the private sphere, but not in the public sphere. This court is removing that. So the point is, this court is reading the religion clause and the Second Amendment for all they're worth. So if they can read some provisions broadly and to have a major effect, you would think they would do that with the 13th, 14th, and 15th Amendments, for which a horrible war was fought to have, and for which the court at an earlier day had said those amendments would not have been passed except for the war, emancipation, and a desire to free an entire race. But this court, has been interpreting those amendments, 13, 14, and 15, to be the minimum they could be. So they're picking and choosing the constitutional clauses that they like and don't like. And unfortunately, they're picking them in a way that magnifies stratification in our society, that magnifies separation, that magnifies the disadvantaged, the disadvantages of people who are disadvantaged, and really turns our society on its head.
And I want to really follow up on that question, because for our students, they know that the 13th Amendment ends slavery, the 14th guarantees national citizenship, and the 15th guarantees the right to vote regardless of race. But as you already mentioned, all three of those amendments have only been really greatly enforced in a specific time period, 1930s to the 1970s. So could you talk a bit about how those amendments were used in that time period first, then we'll get to what's going on in a contemporary context.
Okay, I'll give you two examples. Number one, by the 1930s, segregation, which was segregation was really a form of total stratification and totally unequal society. And the 14th Amendment seemed to have no role. The theory was separate but equal, but it was really separate and unequal. Starting in the 30s, the court started chipping away at that, and by the 1950s, the court said no segregation. The segregation was unconstitutional. And in the remainder of the 50s after Brown versus Board, and in the 60s, up until the very end of the 60s, and even into the beginning of the 70s, the court was trying to make real not simply the end of formal segregation, but was trying to really make real the promise of equality that the 14th Amendment, Equal Protection Clause, meant. Since that time, they've gone in the opposite direction. Another example is the right to vote. Until about the late 1950s, there really was no right to vote, not only on race but anything else. And in the 60s and the 70s, the Supreme Court, along with Congress and the executive branch, really created a vibrant right to vote, protecting all races and protecting all voters regardless of race. And there too, at least since in more recent years, the court's been dismantling that piece by piece. For example, we all know about how the Supreme Court about 10 years ago just did away with the Voting Rights Act, did away with preclearance, which was the main engine in achieving some racial equality in the southern states. The court just did away with it. And they did away with it by lying about what an earlier opinion said. They did away with it by quoting, they said, our view on this is supported by a case called South Carolina versus Katzenbach. And then they quoted a sentence out of the South Carolina versus Katzenbach case, except they left out 20 words that showed that they were lying. They said South Carolina versus Katzenbach held such and such, but it didn't. It held the opposite. But they left out 20 words that showed it meant the opposite. So this court has been going out of its way to undo the good that the court in the middle of the 20th century had done.
And I would point out too that you mentioned this goes from the 1930s to the 1970s, and then 1980 we get Ronald Reagan, we get the conservative revolution in politics, and a sea change in the Supreme Court. So I can't help but think about the fact that these Reconstruction or Civil War era amendments were made during a time of considerable turmoil in American politics, but also a time of real potential in the 1860s and 1870s in terms of ending slavery and the like. And then they're being utilized through the New Deal, Great Society era of the mid 20th century. How important do you see these Reconstruction era amendments in terms of safeguarding democracy in the future? Because they're being referenced a lot more and more, especially the 14th and 15th Amendments when it comes to, as you mentioned, voting rights and other key issues. How important will it be for not just the Supreme Court, but even everyday activists to cite these amendments and say we have to utilize the full letter of the law to safeguard our rights?
Critical. And one way to see that is to see what happened in an earlier time. One of the tragedies of American life is that the period after those amendments were adopted in the 1860s, the Congress followed up with some civil rights laws designed to protect the right to vote and protect the newly freed slaves and protect their white allies and to encourage a real democracy in the South. And the Supreme Court of that day just wrecked those laws. They held a lot of them unconstitutional. So, for example, the Congress passed laws in 1870 and 71 that authorized the federal government to prosecute individuals who were violating other people's civil rights. Okay, Supreme Court threw those laws out. And yet, so that in the 1950s, when there were riots, to maintain segregation. Say Little Rock, when crowds were gathered at Little Rock and throwing bricks and bats at the Freedom Riders in Birmingham, if those laws had not been thrown out by the Supreme Court, federal agents could have arrested the rioters, and a handful of arrests at Little Rock or at the Montgomery bus station probably would have ended those riots pretty quick. And instead, federal government couldn't do it. They didn't have the power because the power that Congress gave them had been taken away by the Supreme Court. So the Supreme Court has the power to nullify what Congress and the president try to do on behalf of the people. And that's what they're doing again. So
now, in your personal experience working on voting rights cases and voting rights issues, how important has the 15th Amendment especially been to your work? Because it has, I think, perhaps become the best known of the Reconstruction era amendments. How important has it been also, especially to the Voting Rights Act of 1965? How important have those two, of course, the Constitutional Amendment, 15th Amendment, and the Voting Rights Act, how important have they been to your career in terms of doing voting rights activities, voting rights actions?
crucial, crucial. The I, for example, I did I didn't vote for president till I was 34 years old because I missed, I think, 4 elections in a row because of laws, state laws that disqualified me.
Mm.
You had to wait till you were 21 to vote. You had to live in most states for a year. You couldn't vote absentee in a lot of places. All those things. Well, a lot of those things were eliminated by the Supreme Court and with Congress cooperating and so forth. So those things don't exist anymore. But if this Supreme Court had been in charge in earlier days, those restrictions would still exist. They would still exist. This Supreme Court favors restrictions on the right to vote and uh, and doesn't care and will overturn lower courts that try to get rid of those restrictions. I'll give you a little known example. You know, we all know the dramatic examples of the Voting Rights Act, but for example, there's something called the motor voter law,
Mhm.
passed by the federal government about, I guess, in the 1990s. And one of the things the motor voter law does, in addition to encouraging registration, is it regulates states' efforts to purge voters. You know, sometimes voters have to be purged if they move or die, and so states are allowed to purge voters if they do it in a reasonable way. And a case came along to the Supreme Court in which a state, Ohio in that case, had gone way overboard and kicked a ton of people off the rolls who were still registered. And there was a challenge to that, and a lower court said that challenge was correct. Ohio has gone too far, and it's not reasonable. It went to the Supreme Court. The Supreme Court said, oh, yeah, Ohio is just fine. And not only that, they said, oh, this word reasonable in the statute, it doesn't mean anything. When Congress said the purging of voters has to be done in a reasonable way, we don't care about that at all. They just threw that word out of the statute. Congress had put it in for a very specific reason. And this Supreme Court said, we'll just throw it out. So they pick and choose what they like and what they don't like.
I think all of this is, of course, leading to a question many of our students have right now, which is how does this all relate to the current legal issues a particular candidate for president is facing right now? Of course, I'm talking about Donald Trump. Now, it appears that the Supreme Court is really trying to stay away from making any rulings that could get Trump in further legal hot water, so to speak, although I think at this point that the water is kind of boiling for him. But could you talk a bit about the Supreme Court's role in all of that, in trying to keep Trump in these debates about taking Trump off the ballot in certain states versus keeping him on, and how this is playing out in the legal arena.
Well, the Supreme Court claims to be just calling balls and strikes. That's what Chief Justice Roberts said was the Supreme Court's job when he was in the hearing. That's not what they're doing. So I'll give you an example. There was a case from, as you know, from Colorado, which had kicked Trump off the ballot, and it went to the Supreme Court. And the Supreme Court said, and I think this is actually correct, that the states couldn't do that. There's a clause in the 14th Amendment that says if you've been in an uprising or attempted to overthrow the government, you can't hold office. Okay. So Colorado said, well, Trump has been in an attempt to overthrow the government, so we're kicking him off the ballot. The Supreme Court said the states can't do that. And I think that's correct, because it wouldn't make sense for Colorado to say he's off and Massachusetts to say he's on and Florida to say he's off and some others. That wouldn't make any sense. So it's clear that the federal government is the one to enforce that. But the court went on and didn't have to do this, but said only Congress can do it, making the courts giving the courts no role. They didn't have to decide that question at all. And what they really did is they protected Trump in that way. The other thing they're doing is when the Supreme Court took up this question of immunity, about whether the president is immune from prosecution, I have to say, I sadly predicted what they would do. We don't know yet what the opinion is going to say, but everybody says, well, the Supreme Court is going to reject total immunity. In other words, they're going to say, the president can't just pick up a 6-shooter or a rifle and walk down the street, mowing people down left and right and not be prosecuted. They're not going to do that. And of course, they're not going to do it. But I said, unfortunately, I would turn out to be right. They're probably going to deny total immunity, but they're going to do it in a way that makes sure he doesn't get prosecuted for a long, long time. And that's what they are going to do. They're going to say, I'm pretty sure of this, they're going to say, he's not got total immunity, but he has immunity for certain things like core presidential function. And before you try him, you've got to figure out which is which. And so it'll take years before he gets to trial. So I knew they were going to do something like that, and sure enough, they are. So while pretending that they are neutral, they're anything but neutral. When you haven't asked about this yet, but obviously abortion is sort of behind everything, and yet on abortion, we know that the justices who got rid of the abortion right to abortion had that in mind all along, and yet they got on the Supreme Court by lying about it. They wouldn't have passed the Senate Judiciary Committee to get on there if they really had told what they really had in mind. But they ended abortion with an opinion that 11 times relied on an English judge, Justice Hale of the 17th century, who during his time as a judge spent a lot of it trying, convicting, and hanging women as witches. So that's their authority for getting rid of the right to abortion. The interesting thing is that the court, and this brings us back to the right to vote, by the court restricting the right to vote, they're putting state legislatures in charge and putting the voters out of the picture. And yet we know that state legislatures are in many instances restricting the right to an abortion severely, while the people in those very states have very opposite views. So the Supreme Court is limiting the right to vote to make sure that the legislatures can act like real criminals.
Now, I want to end our interview with some more useful information for our students, many of whom are going to become activists in their own right in a variety of projects, all of whom are deeply concerned citizens. So I'll ask it to you in this way. What would you say to people citizens, activists, so forth, who are deeply concerned about the direction of the Supreme Court and what it's done on abortion, on voting rights during the era of Chief Justice John Roberts, before him, William Rehnquist. What is it that average citizens can do from here on out to respond to what the court is doing?
I wish I had an answer for that, because part of the problem is that this Supreme Court, more than any other, seems to care nothing about public opinion or about other people's views of the Constitution. This court, more than almost any other in history, I think, is not just a reactionary court, which others have been, but is out of step with the people. When the court in 1896 said separate but equal in Plessy versus Ferguson, the problem is probably most people thought that was just fine. But
Right.
nowadays, the people are just up in arms, I believe. And the courts, the examples of the courts uh, seeming crookedness uh, fits in with that. And so the court's uh, rating in public opinion is really at its rock bottom. And one has to think these justices are not going to last forever. And some of them are going to disappear soon. At that point, it'll depend on who gets to nominate and confirm them. But I guess the only thing we can do at this point is to keep the pressure on, keep trying to exercise power in in our democracy, and in the end, I think we have to hope that the court cannot sustain its bad role against committed democracy. Which means, of course, the elections make a difference too. So
Absolutely.
we have to
So in
hope
other words,
that the elections turn out to really reflect the voice of the people. We have to hope that the people are sensible. Let's
well,
keep our fingers crossed.
fingers, toes, and anything else you can get crossed, let's keep them crossed
Exactly.
this November, because you're absolutely right. There is a lot of work for us to do, but I think the good news is that individuals like yourself and Vernon Burton and others are doing the necessary work of getting information to the people through books like Justice Deferred, to kind of help us think about all these topics in a both a historical context and a contemporary context too. So I do want to thank you again, and Dr. Burton, for your work on this book, and I want to thank you for your work on voting and civil rights as well, and for
Thanks, and
joining us this afternoon.
thanks to you and Brett and others and the Simkins School. I was Modjeska Simkins was a friend of mine. I worked with her.
Mm.
She was a wonderful person, and the people who come to this school and work with this school, like you and the students there, are carrying on a wonderful tradition and a great torch. And we will prevail. We will prevail.
Absolutely. We will prevail.
Thanks so much for inviting me.
Thank you for joining us. All right. Yes, please give Armand Derfner a wonderful round of applause. Again, that was our interview from yesterday. And what I'd like to do now is to go ahead and transition to talking to Dr. Vernon Burton, who is the author of books such as The Age of Lincoln and a co-author of Justice Deferred, Race, and the Supreme Court, and is currently a historian based at Clemson University. I've always joked that he is, as a Gamecock, he's one of the best things I like about Clemson. So I think that's the highest compliment I can give. But Vernon Burton, welcome once again to the Modjeska Simkins School of Human Rights.
Thank you, Robert. It's always a pleasure to be here and meet folks and listen to their good questions. And I just want you to know it was my dream to always teach at University of South Carolina, but it took them a long time to even want me to even come there to speak. So glad at least those days are past.
Definitely. Well, what I want to do is actually pose some of the same questions I did to Mr. Derfner to you as well. And in particular, really emphasizing the importance of the Civil War or Reconstruction era amendments in today's political, social, and cultural discourse. So my first question to you, Dr. Burton, is why are the Reconstruction Amendments, the 13th, 14th, and 15th Amendments to the Constitution, so important to having a modern understanding of the U.S. Constitution?
Well, as Armand said, of course, is how they are read. And one of the things that we show in the book is that, from the beginning, there were some judges, particularly at the district court levels, that had very difficult dealing with the 13th and 14th Amendment, which are very clear. They're very clear what they're doing, but the judges had grown up in an era where the states had all the rights reserved to them. And what the 13th and 14th and 15th Amendment did very powerfully was to change that relationship. So the federal government insisted that it had the right, the courts said that it had the right to enforce that people were free, that they had equal protection under the law, that they were citizens with all the rights. All citizens had equal rights. And each one of these amendments, 13th, 14th, and 15th, should have been enough. But when it was shown that it wasn't, then the 15th Amendment, particularly for voting, and I cannot emphasize how important voting is. If we take away anything from this, it is our understanding of voting in the United States. We can disagree. That's partly what democracy is supposed to be about. But what people seem to not understand is that when you're voting for the president, when you're voting for a senator, when you're voting in a congressional district, it's not a parliamentarian form of government. It's a winner take all. So you may not like that somebody wears pantsuits of a different color. You may not like that somebody is 3 years older than somebody else. But when you vote, you need to think very seriously about that election and what your vote means, because the person who is president will appoint not only Supreme Court justices, and look what a difference it made that Jimmy Carter got to appoint no Supreme Court justices, though he appointed like 3 times more women and African Americans that had been appointed by everybody added up to him on the federal courts, including Ruth Bader Ginsburg, but no Supreme Court justices. And those are going to be crucial. We are so far behind the 8 ball now. So please think how important that vote is. And while I'm at it, let me add something to Armand that Armand didn't say. Yes, vote. That's important. Even if you're going to vote the way I don't think you should, if you care about democracy. And democracy is a fragile thing. It is not stagnant. It changes. That's part of the things we show in our book, both in the age of Lincoln and in Justice Deferred, that democracy evolves. It can not only go forward, but it can come backwards. Brett and I are old enough to remember some of these changes over time. And I think we're at a very critical point in our democracy. But it was hard for people to read it then. But those amendments changed the Constitution. I've pointed that out. Eric Foner has pointed that out, called it a second founding. But it really makes the Constitution a different one. I think I've stated this here before. It's one of the things I like to state and restate. I believe that particularly Abraham Lincoln, in his own way, took the mission statement that came from Thomas Jefferson, of all people, that Declaration of Independence that said all men are created equal, and he put it into our rule book, first with the 13th Amendment, which still wasn't ratified when he died, but certainly the 14th and the 15th were done in his name, calling on the legacy of Father Abraham. And Lincoln told a powerful story. He actually wrote this out in a letter when a African-American church in Baltimore had sent him a Bible. And he sent back a letter, and he said that our country, that is the United States, has never had a good definition of liberty. He says that the wolf says that he's being denied his liberty when the shepherd keeps him from eating and killing the sheep. And the sheep will thank the shepherd for protecting them and giving them the liberty not to be killed by the wolf. And basically, he's talking about Isaiah Berlin's 100 years earlier, positive and negative liberty that's being done in the Constitution. He made clear what he was talking about when he said, especially when the sheep is a black one. However, as Armand said in his interview, these textualists and originalists in particular, they read that First and Second Amendment. They read it wrongly on guns and the militias, he pointed out, but they read that one and religious freedom as broadly as it can possibly be read using the language there. And they are now trying to read the 13th and 14th and 15th Amendment in probably the most narrow way it can be read. In fact, I do not see how an originalist or a textualist can read the 13th and 14th and 15th Amendment and make the rulings they're making now that do not give those rights to minorities and particularly to African Americans. Armand talked about a little bit about the what we argue in the book and what I had argued previously in the Age of Lincoln, that Reconstruction was set up for success, not failure. We read it backwards. We know that it was overthrown, coup d'etat, terrorist organization, ended Reconstruction in our home state of South Carolina. But when Reconstruction was set up, African Americans had the vote. For the first time, they had a seat at the table. And in South Carolina, they are a large majority of a voting majority as well. And they voted and they knew how to vote. They knew what their interests were. One of the greatest myths of all time is that they were not prepared for citizenships. There's never been a group of people who understood what their rights were and what they needed and how to vote than African Americans at that time. That's why I argue even afterwards, all the way through Dr. Mays and Dr. King, that this is sort of the legacy of Lincoln's millennial vision in the belief in America and in democracy that's coming out. So I've gone too long, but I want to just remind one thing of contingency and what a difference it makes. And this is one of the things I think we do pretty well in Justice Deferred, the difference it made to have Lincoln as president and his successor. When Lincoln was assassinated, the cabinet was equally divided about whether to, when allowing the Confederate States back into the Union, they would have to accept and write into their Constitution that African-American males would have the right to vote. Charles Sumner was so sure it was going to be done, he wrote elatedly about it. When Lincoln then spoke the famous speech, particularly impromptu, and if you want to understand what Lincoln is thinking, it's hard to do with his writing because he was such a careful writer and such a careful politician. But these impromptu speeches, as when he left Springfield, when after Robert E. Lee's surrender, he is on the White House balcony speaking, and he talks about Black citizenship, especially for the soldiers, expect that, and what he called more intelligent African Americans, though we look back on it and say, oh, what a racist. Why didn't he say everyone? But if you think where America was at that time, and my argument in the Age of Lincoln, where he is bringing America is pretty radical. And one person sitting there understood exactly what Lincoln was saying. And he turned to his compatriot and he said, he's talking about, he did not use this word, but Black citizenship. That is, Blacks having the ballot and the right to vote. He didn't say that. That's my interpretation. And then he said, that'll be the last speech he will make. And a few days later, that man, John Wilkes Booth, killed Abraham Lincoln, which I argue puts Lincoln in a long line of martyrs who were killed for advocacy for Black voting rights. More than we'll ever know, I suspect, who were killed, starting early in Reconstruction and going at least well past the Voting Rights Act of 1965. And I've said it again and again, we have to understand that terrorism did not begin with 9/11. African Americans particularly in the state of South Carolina, but in most of the former Confederacy and other places, lived in a terroristic society, at least until the Voting Rights Act 1965, and the importance of that vote and how central the vote was. What Johnson did was immediately the first state that is admitted under Johnson is North Carolina. With the cabinet evenly divided, he did not even consult with the cabinet. He put a grandfather clause into the North Carolina, which was his native state where he'd been born. We think of him as Tennessee, and he also lived in Lawrence, South Carolina as a tailor for a while. So we have some claim to Andrew Johnson too. And he said that in that Constitution for North Carolina, that no one who had not voted, and I believe it was 1864, I might forget the year, could not vote in the post-Civil War period. So it was a grandfather clause that became very common then as a way to disfranchise African Americans. Another thing, when I did the felony disfranchisement case, I discovered was that en masse, because there was a law in North Carolina even before Black people got the vote, but people knew they or believed they were going to get the vote as early as 1865, because you had all these activist African American conventions meeting throughout the United States advocating for the ballot. And so North Carolina literally rounded up 2,000 African Americans and whipped them, because if under North Carolina law you'd been publicly whipped, you couldn't vote, which was the kind of thing I found that I wrote the article that got me in so much trouble with so many historians in South Carolina and universities, the black squint of the law, that the 1895 Constitutional Convention tried to pick out the laws that they thought that were most likely to be committed by Black citizens and make those felonies so they couldn't vote. So you have the incredible situation in South Carolina in the Constitution that if you beat your wife, which they believed African American men did, there's no evidence that I see it, then you could not vote. But if you beat her till you killed her, you could vote, because you didn't lose your it was not a felony to kill your wife, only if you beat her. That's the most ridiculous thing. The things that are most common are like stealing a pig or something like that. Well, I've run on too long, Robert, but I hope I got to the question you were coming to. One other thing, though, to Armand, I do want to say is I do believe this. It's not just voting, as he advocated. I think that we need to organize as well. I think whether we believe the Supreme Court is immune to public pressure or not, they need to know how people feel, if they feel that way. That's why I keep doing these amicus briefs. I don't want the excuse that we as historians for years gave the past. Well, that was a different era. They did not know. And I may have said this before when we talked. Read the dissents. I mean, the most terrible, at least most people agree, infamous court case is Dred Scott and Roger Taney. Read those dissents. He knew he was lying. The other two justices told him, who dissented, and said African Americans had been citizens. They voted in 5 states. They voted in North Carolina, a slave state, on the same restricted rules as whites did. And they made a difference in those elections. John Hope Franklin showed that in his early work. A number of other people have shown that. Lacey Ford, South Carolina, looked at this question, and they were making differences in close elections, a very thing that later Tillman would be afraid of in South Carolina if Black people were able to vote and could make a difference. Why he went for total disfranchisement instead of just using limited disfranchisement. Worried that whites and Blacks, farmers, for instance, in the populist movement, the Granger movement, might get together and vote as a coalition, as many did, a lot more than people want to think did in Reconstruction. So I believe that it's not just voting, but I think we need to let people know. You need to mobilize people, just as we did in the civil rights movement and voter registration, that you need to mobilize people and let people know that you are mobilizing people, and the reasons you're doing that if you want to make a difference. The Constitution's still there, and we still have some very, very good judges who are pointing out the fallacies, and I think they're doing their part there. I think we in the public, the people who care about democracy, need to do our part.
No, I think that's a great way to really get at the key issues we're talking about this afternoon. I want to pose one more question before turning it over to the audience for our Q&A session, which is this. Earlier, you mentioned in your answer that an originalist or a textualist interpretation of the 13th, 14th, and 15th Amendments to the Constitution would actually empower the Constitution, the federal government, to do more on issues of civil rights. Could you expand on that response a little bit more in terms of how
Sure.
we tend to think of originalism as a way to look at the Constitution in a conservative light, but you're saying actually with those Reconstruction amendments, it's not so simple as that.
That's right. And if you're honestly, it's not that simple with the other amendments either. They pick little parts out, like as Armand talked about, the gun control was clearly accepted precedent that it was militia controlled. But the 13th Amendment was first interpreted to end the badges and bondages of slavery. Now, not being able to vote would be one of those badges or bondages, and it was sort of expected that would be a natural consequence of it. So that's a powerful amendment. And one of the things Armand and I have talked about and wrote in the book, Judge Roberts has really gone after the Voting Rights Act. That was one of his pet peeves when he was in the Justice Department as a young man. I'm hoping that he's seen when he said that you had Section 2 left when he got rid of Section 5, whether he did it dishonestly or some clerk of his did it dishonestly. But as Armand and I show, I think no one else has shown this before, that they totally misquoted the basis of a 8-to-1 opinion. Only the Southerner Hugo Black, like most Southerners who resented Section 5, that said those states that had the history of discrimination and also statistically denied people the vote had to have their laws pre-cleared, which sort of makes sense to me logically. I don't see how you can point to it, but even Jimmy Carter in 1972, most Southerners sort of, we always feel, white Southerners and some black Southerners, everybody's picking on us all the time and feel aggrieved. So even Jimmy Carter, in 1972, when he was I forgot the name of the office, but the Governors Association chair, president, whatever that is, he wanted to demand at the Democratic Convention that they get rid of Section 5. And they have now done that. But Carter, I'm doing a review now of his diary for a little book that's coming out on his literary achievements. To Carter's credit, by 1976, he's saying the Voting Rights Act's the best thing ever happened to the South. It's just unfortunately he appointed Griffin Bell, who never did change, as his Attorney General on these things. But Carter did make some good judges appointment, in particular, as I said, really expanded African American. The 14th Amendment. Now, Armand and I go through to show how with the Ku Klux Klan Act, the Civil Rights Act, all these protections with blacks at the table and the right to vote, how could Reconstruction not work? And we argued that there was like a brick wall or stone wall built to protect black people with these other laws. And then there's a series of 6 court cases that takes one stone out at a time. One of the biggest misconceptions is Reconstruction ended all at one time. Read the sources, go back to the primary. It did not. People even thought, well, 1876, we'll have another shot and we can win in 1878, 1880. And that's when it's one thing at a time. First, you close down the number of polling places, particularly those where there are a lot of African Americans. Does it sound similar? I just did a Georgia case and showed exactly the same things happening in Georgia that happened during Reconstruction. Until you pretty well have one party in a state in control, then they can do what they want to. It happened before. So the first ruling, I mean, you can skip the Blyloo case, it should have been a warning, because this was who could testify in court. Kentucky had a law, 1872, that said blacks could not testify against whites. In a deliberate murder and motivated by the idea that blacks would vote, a family was killed in Kentucky. And they thought they had killed one person, but before they died, they were able to testify. And then there was a young girl they missed who was able to testify. And so they convicted the people, went to the Supreme Court, and the court said, well, the way the 14th Amendment reads is that you have to be the person affected. And since a person is dead, then they can't testify, and the other person was younger. So that became sort of a warning of where the court was going. Slaughterhouse, while we've always looked at it as being terrible, 1873, it actually is a good ruling that I used in my debate with the Federalist Society in Raleigh, and they couldn't answer it. It was basically they rule as the reason that they rule and hurts in one way the 14th Amendment, but it's because it's white butchers who were mainly Confederates, and the person arguing the case was someone who'd been on the Supreme Court that left and became a Confederate and was hated by the other Supreme Court justice, of course, because he's seen as a traitor. And they say that the reason that they're ruling against is that these are whites. And they say very clearly that the 13th, 14th, and 15th Amendment were put there for Black people to ensure that the formerly enslaved and African Americans would have these rights of freedom and the right to equal protection, and the right to vote. And it says very clearly in that decision that that's what those amendments were about. Now, if you're a textualist and you read that, you should follow it. That's the first time that it is interpreted by the Supreme Court. And then you go from case to case. The worst, I guess, to me, well, they're all bad, but the Colfax case, when that comes down, the Colfax massacre, where African Americans are murdered, person's convicted, it goes up to the court, and what does the court say? You cannot convict a white person who has murdered in cold blood Black people unless that white person is part of the state. That is, if he were like they were in Orangeburg, the Highway Patrol or the National Guard or something like that, or the state militia. And that sends a message. It's not long after that comes down that attorneys who are commanding the troops in Hamburg, South Carolina, and then later in Ellington, murder and massacre Black people in South Carolina, because the court has said you can do that as long as you're not part of the official state. And each one of those goes like that. For instance, West Virginia had a law that said that Black people could not serve on juries. So the Supreme Court said, well, that law is illegal. Black people have the right as citizens of the 14th Amendment. Virginia did not have a law that didn't say Black people could serve on jury, but no Black people served on juries. They weren't selected. So in the Reeves case, same year comes up, they say, well, that's okay. It doesn't matter because it doesn't say that Black people can't be on the jury. It's just that the people who are running the government, choosing the juries, just aren't selecting any Black citizen to be on the jury. And that gives the basis then for the kind of thing that Tillman in Mississippi did first, which was to write constitutions that don't say Black people can't vote, but they say things like, if your grandfather voted in 1860, then you can vote. Or you have an understanding clause that if you understand the Constitution, then it's okay to go ahead and be able to vote, even if you cannot read it. And the person who's doing that is the poll watcher, who in all these cases are whites at the polls. So using that neutral language. Does that answer where I'm going to? And what happens is one case after the other, including the civil rights cases in 1875, they take each of those blocks that gave those protections that would have made Reconstruction work. And as you know, I argue very strongly, it's a myth that Reconstruction wasn't working. It was working really well, the most progressive Constitution the state of South Carolina's ever had. The great Robert Smalls in that Constitution Convention of 1868 introduces for the first time in any state mandatory public education for all children, black and white. It was extraordinarily progressive. Well, we talked about that when Fergus was at my house, I think. At any rate, don't want to repeat myself, so you'll have to reel me in.
No problem at all. And we'll direct students to that previous discussion as well, because that's also relevant to today's conversation. So I like to go ahead and get to the Q&A. We already have a few questions in the chat. So if you're on Zoom, please put your questions in the chat. And we're going to have to try to go through these as fast as possible, because there are some really good questions in the chat. I want to get to all of them this afternoon. So first,
Robert, can I say one more thing quickly?
Sure.
Then Armand said we'd been known each other forever in 1980. I remind Armand, because we got pretty depressed with these rulings that have been coming down, but we met because the civil rights community was in a crisis, not unsimilar till today. Mobile versus Bolden in 1980, the Supreme Court said it did not matter that laws discriminated. Sounds very much like what's going on again, in fact, with these recent courts. Didn't matter in this case, a voting rights case, that 40% of Mobile, Alabama, African Americans could never elect anyone to the city council. That what had to matter, the Supreme Court said, was the intent and purpose of those people who made that law was to keep Black people from being able to elect someone. And the civil rights and voting rights lawyers like Armand and another South Carolinian, the Armand's an adopted South Carolinian, the great Lachlan McDonald was from Fairfield County, South Carolina. And they were really what to do. And that's when they knew that what do historians do? They look at intent, they look at purpose, they look at what the motivations behind. We have methodology that shows us how to read sources and make the arguments and show what people's intent behind those laws were. And if you read one chapter, I think one of the most original in our book is The War of the Words, Purpose and Intent, or Purpose, and Effect, I guess, or Intent and Effect, because I think we lay that out, which people haven't understood. And it's very interesting how the courts come back to this very difficult thing, because it's very hard to prove intent. And that's why getting rid of Section 5 was so terrible, because you didn't need to go to all this, and you didn't need to have individual plaintiffs having to, these voting right cases are so very expensive. I can remember doing one, and in fact, it involved a little bit Modjeska Simkins on Kershaw, and the NACP was so broke, they had not enough money to buy the transcript we needed. And we had exactly, I'll always, say my wife is a saint, because we had 5 kids. I love, well, you know what the professors get, Robert, and me, assistant professor, and we had exactly $5,000 saving. I was working security guard midnight to 8 to make ends meet so that the third daughter could take piano lessons. And she took all that money, and we bought that transcript because NACP had no money back then. It's a little different now, but we were in a crisis back at that time at Mo. And we came together, and what did happen, you may not be able to lobby the Supreme Court, but you can lobby your legislature. What we forget is there are 3 branches of government. And we went to work, and Armand was one of the leaders of this renewal of the Voting Rights Act in 1982 that said you could have purpose or effect. You didn't need to show purpose and intent anymore. You can lobby your legislators. And this is the first time that voting rights, citizenship right, democracy itself, it seems to me, has become partisan. It was always bipartisan. You have to remember that even as late as 1980, many Southern Democrats were the ones who were trying to stop Black people from voting. And so it had always been bipartisan. This is the first time it had been. I think we need to, whether you have a Republican congressman and senator or a Democratic or an independent, call on them not about whether they're Republican or Democrat, but about supporting democracy and the right to vote. How can anyone in a democracy want to deny people the right to vote?
No, that's an absolutely important point for us to highlight. And this actually is a perfect segue to the first question in the chat from Tiaba Sadiq. She posed this question: what advice do you have for people in office who repeatedly refuse to vote for issues their constituents repeatedly bring to their attention? Is that a form of discrimination that deters people from voting for the same people again, or from voting at all?
Well, I think the vote is about the only protest we have. And I think people do look at votes. I think part of it is what I talked, you got to have a movement. You want to get other citizens so that you're not a lone voice, petitions to them. A number of people standing at their offices demanding to meet with them because they're not supporting democracy. Don't say you're not supporting the Democratic Party because they're a Republican, or the other way around, but say we want you to support basic rights of democracy, the treasured right to vote. If we lose that, what do we have left?
That's a really important point. I think people have to understand, again, what the stakes of so many of these debates are right now. And I've been doing the Modjeska School since 2019, and it seems that in those 5 years, these debates about like basic debates about democracy and what democracy means, have become more and more partisan, more intense, and more critical to really figuring out a way forward. But to that point, and I think this is an interesting question from Cecil Cahoon in the chat. He goes back to Armand's interview and asks this question. Armand began his discussion with Dr. Green by saying the Supreme Court once was seen as a defender of democracy, at least during a period in the mid-20th century. By 1980, that view had begun to shift, and the court's role as democracy's defender has worsened since then. In view of the court's entire history, it is possible that the court's mid-20th century record was an anomaly, and that what we consider a worsening of the court's defense of democracy is only a return to earlier norms. If that is the case, have we already lived through the best possible era of American history, at least until another Earl Warren-esque court is seated?
You know, I would hope not. I think he has a really good point, and we argue that it's only that point. But I want to point out again, you know, as I like to say, when Armand and I met in 1980 and started working on cases together, it was right out of Casablanca. You know, we argued the whole time, but it was the beginning of a beautiful friendship, and it was discouraging then as well. But I honestly believe. I look back I look at Justice Harlan, racist. He said he was racist, but he gave those great dissents that become sort of part of our heritage and people's study. And then you look at someone like Lincoln, who was a railroad lawyer. I wouldn't have thought Lincoln would have ended up being, I mean, I know he's disputed now in so many ways, and nobody, I think, but me likes Lincoln anymore. But you would not have expected him to have gone where he did, I think. But my real interesting hero that came out of this was Charles Evan Hughes, who, you know, I went to Princeton, and this is before we knew very much about Woodrow Wilson, except we understood that he had, of course, segregated the federal government. But the real power of the racism had yet not been uncovered, and how much that influenced Wilson, and particularly the strong Southern bloc of Democrats that he relied on in his things. And so, you know, coming out of Princeton, you know, Woodrow Wilson was something of a demigod, and at least he did some things about caring about world peace that balanced out a little bit of it. But Charles Evan Hughes was a corporate lawyer. But what's amazing is that was the turnaround for the court. Hughes, for the first time in the 1920s and 1930s with the Scottsboro case. Until then, people forget that African Americans protested in South Carolina that Constitution. And they won at the federal level that the 1895 Constitution was illegal, that it was unconstitutional, what it was doing. And it went to the Supreme Court. And, you know, we have a redistricting case that's just sitting there now. Well, the same thing happened. And then they said, well, that's probably right, but, you know, you've already had elections under it, so we're going to let it stand. But the idea that African Americans just sit by idly is part of that myth. They challenged it in every way. Then you have the Phoenix riot, Ben May's first memory. They're out there getting affidavits so they can prove that they were being denied the right to vote, to get federal regulators to come back in. And we don't tell that part of the story. So I think those are important lessons we can learn. When Hughes said, let me see the evidence, you can see why a historian cares about this. It just didn't rely on what the South Carolina Attorney General or the Oklahoma Attorney General or their courts has said, and looked at the evidence they based it on was the turnaround for that court. It was before Warren. It was really with Justice Hughes. And, you know, I make the argument, of course, that it's not just an argument, it's clear. The great Thurgood Marshall, he hardly ever, he won almost every case. No one thought he could win those cases at the Supreme Court that he did. He won nearly every case until he gets on the Supreme Court, and then he's on sort of the losing side the rest of his time, one of these great ironies. But remember that Thurgood Marshall gives us another model of someone who did not give up when people said there was no way you could win. He still won in the court. And I still believe that this is our hope, evidence. That's why I do what I do. That's why I think we do. Give people evidence. And then they got to decide, you got the evidence? Here is the evidence. Now, deny the evidence. But if you don't, then what is your reason for ruling the other way? At some point, they've got to confront and say, I'm just a racist, or I'm just a partisan person if I'm ignoring the evidence. And the court has to be evidence-based. And Robert, the Academy didn't do us any favors with this idea that postmodern history, let alone, you know, I blame the literature people because I don't like to blame my own folks, but the idea that all stories are the same, that, you know, there's no such thing as fact, then that becomes alternative facts. Evidence is real. I like to give that quote that I use a lot, that, you know, it's the Adams, who was a historian, who wrote that no people are more ignorant of their history than Americans. And then, though it is his great-great-grandfather, we need to remember he and his son were the only two presidents, John Adams and John Quincy Adams, who were opposed to slavery among the founding fathers, the first presidents, who said that facts are stubborn things and you cannot ignore them. And so that's the other thing we can do. We can bring out the facts. We bring out the evidence, not just opinion. People are right to have their opinion, but let them base it on evidence and argue with the evidence. And I really do think the evidence on the side of democracy, despite what this court has been doing. I mean, I think it has become very clear. Armand mentioned the line I've used over and over again, that this is the first court, I think, in the history of the United States that has been so out of sync with where the people are in this country. I think we, in the book, we struggled night after night. We were so depressed as we went through the end of the book, where we were and where the court had gone. And then we struck upon what I think is true. Young people today do not want to be discriminating. They want fairness and they believe in it. And as long as they know that, and if they will use the vote, and they will understand the importance of it is we're not a parliamentarian form of government. You're going to vote for one or two people, and any other vote is going to be a vote, even though you may have to hold your nose. I think you want to hold your nose for the one that's going to do the least damage and try to save democracy to the one that's already told us that they don't want to have democracy. So I still think there's hope that way, and it's with the young people and evidence.
Well, most definitely. I will say before we get to the next question, I'm not sure that we'll have time to get to all the questions in the chat, so I want to apologize in advance, but I'm going to try to get to as many as we can before we run out of time this evening. Okay, so I want to get to a question that Greg Howell posed. And he posed a couple of questions in the chat, but I want to get to one in particular. He said, I want to challenge your thesis that Reconstruction was a success. I don't dispute that there were some good things that came out of it, such as establishment of the public school system in South Carolina, so forth. However, I go back to my contention that without 40 acres and a mule for Black Americans, Reconstruction overall was a failure. So could you respond to that question?
Yeah, I'm happy to. And South Carolina is the one place that set up a land commission that did get the land. And in fact, you might remember that Sherman's order gave all that land to African Americans. And it was not Lincoln. Lincoln let it stand. He agreed with it. It was Johnson. So it goes back to who is president. When you think about these tough decisions you have to make about who to vote for in the next election, what a difference Johnson made versus Lincoln on that. Yes, it would have been so much better, but Black people were not helpless with that vote. When in fact, Black legislators were killed, Lawrence Kane from Edgefield, state senator, Black state senator, who had become a school teacher, put in a bill that you would tax the area of the white landowners to support the widows and children of those people. Think about, we look at tenantry today as this horrible thing that put people into this sort of serfdom situation of poverty in the rural South after the Civil War. It didn't begin that way. Tenantry went back to Jamestown, Virginia, and it was the legislature that determined who got the crop first. And that's one of the things they did. Who got the crop were, in fact, African Americans, or at least the workers on the land first. It was after Reconstruction, they changed it to the landlords, and then they changed it to the store owners. So it really matters, and that was working. You look at the governor's papers, and you find both Matthew Calverth Butler and Martin Witherspoon Gary, the two people who had been generals that rode under General Wade Hampton in the Confederacy, in that celebrated unit. And they're the ones that lead the overthrow, the coup d'etat in South Carolina of the Republican legitimately elected interracial government. And both of them are writing to Black legislators asking them for favors. I argued back in a dissertation at Princeton that I never published that we have not understood this well. We look at it, I was a social historian, so we look at social history, and we weren't looking very much at political history. But I think you have to understand that political power and influence beget economic opportunity. And that's what they were doing through the laws in the South Carolina legislature. And that can beget actually a social equality and integration. And my great example was the white Judge Ramey, a Baptist deacon, who in Edgefield, South Carolina, on the courthouse steps, married his former slave, who had been his, what would you say? You can't really say it's a mistress if she's enslaved because she has no choice, but they get me. And I think that's a great example. You have Black and whites who are partnering in business situations. All of that is pointing toward the success of Reconstruction. Why did they have to overthrow it with terrorism if it were failing? You might want to ask who it was failing to. For the first time, people had to pay taxes, and they didn't like that. But for the first times, they had schools for their children. For the first times, they had incarceration reform. That for the first time, they tried to do something about people who we would today say may have, my daughter will kill me if I use the wrong term, intellectually challenged or what we would call the poorhouse and things. It was an extraordinary progressive period. Until then, men could just leave their wives, go off west, take up another wife. This is sort of what happened with Andrew Jackson and Rachel. That's so celebrated. And the wife was stuck in South Carolina with all the debt of her husband. They legalized divorce, challenging this patriarchal system that held South Carolina in particular in the grips of this elite planter conservative group of people at that time, Democrats. So I stand by it. You know, you can go ahead and believe the myth that most of the people have believed most of their lives of the lost cause and that Reconstruction was this terrible failure. But I think we can't deny that but it was nipped in the bud because I think it was being successful and making a difference, not because it was failing. Black people voted even when it meant being killed, beat, lose their jobs, everything. They continued to vote and vote their consciences and vote for their rights.
Dr. Green, I wanted to contribute
Yeah.
to Greg's question, which I learned from Dr. Burton for last few decades of studying under him, is Reconstruction was smashed because it was so successful. And that it threatened their leadership. And so that's the short answer. And we've been lied to, and we'll get into it when we look at the books, the Sims Oliphant books, about how all of us were taught in the South that the Reconstruction Congresses were buffoons and ignorant people, and it was not true.
Yeah, I wrote an article where I looked at the Sims, but there were 4 mentions of enslavement. All were about how positive it was and how good it was for Black people and how the poor whites suffered trying to help the Black people be enslaved. Reconstruction chapter is horrendous. The Klan saved civilization. The Ku Klux terrorist organization that not only killed but raped women. Cowards rode around in sheets, would never attack where they had a force like the federal forces there. And I think the worst thing for me, and I don't have time to go on about Mississippi and my friend Jim Lowen and how he ended up writing a textbook there on Mississippi's history. But one of the assignments was, and this is a book that Black school children had to use too. It said, write an essay that your father rode with the red shirts to save civilization and white supremacy in the South. I mean, that's pretty amazing when you think about it. It's not only, you remember I've talked about this before, I know, but my favorite picture in the whole book is the very first one that I put in of Thurgood Marshall arriving on the Silver Meteor in Charleston, that great picture that the great civil rights icon himself, Cecil Williams, took. And I put there the quote that Thurgood Marshall said it a little bit before that when he barely got out of Florida when they were trying to lynch him. And he said, sometimes I get tired of saving the white man's soul. So this is not just about Black people. What has it done to the soul and psyche of white children to be told that they have the right, that they are superior? It ends up with an Aubrey Williams down in Brunswick, Georgia, having 3 white men kill him because he's jogging at a place that they don't like him to be jogging and not willing to submit to them, that had gone back to laws that gave slave patrols, the Ku Klux Klan, and then later laws in Georgia as we had in South Carolina. It's a damaging thing for all people, I think, to live in a society of oppression. And that's what we have had. And when we get discouraged, I did want to add one thing. One of the things, and I'm surprised Armand didn't say this, because we worked on this together. When you get discouraged, and I tell him this sometime, you've got to remember that for 12 generations, 12, counting the generation, 25 years since we started laws on race, we had laws that First, since we know there's no such thing as race, I've talked about this before, there's genome project, genetics, there's no difference between me as a Presbyterian than when I was as a Southern Baptist. There's no difference between a Ukrainian and an African or genetic, or as my sainted mother would say, we're all created in the image of God, what I said at church this morning, in fact, when I gave a little sermon. And yet we have racism. And how did we get it? We created laws that for 12 generations in the United States discriminated against one group of people. And it said they had to have an inferior status. It also punished whites who didn't agree with that and wanted to cross that over. So count to 12 and then count to 2. We've only had 2 generations to undo what we did for 12 generations. If you look at it that way, you can get a little more positive and say, well, we've actually made a lot of progress, if you think about it, considering how long we worked to create laws. We immediately, one of the first laws we changed was the English law that the child of an enslaved person followed the status of the father, which meant if the father was white, the child born of an enslaved woman would be free. What did we do in what becomes the United States? We said they followed the status of the mother, which meant they would always be enslaved no matter who the father was. And you can go through law by law and see how we created this, that if a Black person taught an enslaved person to write, 100 lashes, but if a white person taught them, they got 50 lashes, but still whites and Blacks. We made the laws so that whites and Blacks could not cooperate and work. That's why so much, when I wrote the Penn Center book, so much happened there, because it was away from where people knew what was going on, so Black and white could meet together. Even when I grew up in 96, South Carolina, on a little farm outside of it, and I went to work in a cotton mill, the mill was completely segregated. So on the weekends when I worked and African Americans were there for cleanup outside, we used the bathrooms together. We were breaking the law. Taught us to be scofflaws, I guess. At any rate, I think we have to understand what we had. And I am hoping, even at the worst, we will not go back there. But I do think we have a pattern that we have seen, that is not all at one time that things changes, but it's step by step, as they took out one brick or stone layer of that judicial wall that protected African Americans' right, combined with their right to vote, until they got rid of the vote. I think I've told you that in the both the Arizona case and in the Georgia case and in the North Carolina case, the attorney said, because Judge Alito said today is not like 1982. Well, what's the significance of that? 1982 is that renewal of the Voting Rights Act I told you about for 25 years, and really strengthened the Voting Rights Act incredibly so. And so the attorneys had me look at it. In every one of these cases, it was the Arizona case, Bronovich, so in Arizona, exactly that. And when I came back and said, well, you know, actually they were shocked. I said, Alito's sort of right. Because in 1982, everybody believed that people had the right to vote. You'd had the Voting Rights Act since 1965. That's 15 years. People wanted to dilute or try to find ways to make sure that the Black vote was not, or minority vote was, didn't have the same effect. So they were still trying to do at large and things like that. But no one was saying Black people should not vote, as they said so clearly before 1965, right in South Carolina, yelling at the top of their lungs. But today, these laws are not just trying to dilute, they're bringing laws back that try to keep people from voting. This is a real difference, I find. It's much similar to Williams versus Mississippi, or Mississippi versus Williams in 1898. As I said, up until that time, only South Carolina and Mississippi had disfranchising constitutions. And then that green light was given when they understood, as long as you didn't say, we are keeping black people from voting, you could use things like the white primary, anything that was neutral wording, like we mentioned the jury laws in Virginia. As long as you use neutral wording, leave it to the states to control again. And that's why you have the civil rights movement to try to takes all of that. And remember, the civil rights movement was not just Thurgood Marshall. He was not very fond of King, but it was John Lewis and King and C.T. Vivian and some white allies who were out there pushing with the organization too, to get the federal government to do something to bring the Kennedys on board, and finally Johnson to get the Voting Rights Act and to make it meaningful. The other side of that, when we talk about Reconstruction, and I think I mentioned this when Ferguson and I were on, the real difference, I think, and I always put this exam question on for my students, is that the first Reconstruction, people don't like to believe the worst about other people, particularly these fine sounding, sort of God-looking Southern politicians who are up there, and they don't want to believe these horrible things are happening. So all that happened in Reconstruction, the killing, the murder, all of that, they didn't accept it. And the same thing was going on with the civil rights movement until it was covered by the press, till it was on TV, and people saw children hit, beat hoses, dogs attacking people. And then they realized what it was. It was very similar to the Northern soldiers in the Union Army who said they would not fight to end slavery, they'd fight to preserve the Union. Then they got in the South and they saw what slavery was. And unit after unit, soldier after soldier, I wrote about one, changes from anti-black to abolitionist. So it's so important, I think, that we get that evidence out there. I mean, we have seen historically the difference evidence makes.
That's very true. And I'm sorry to do this, but we are running a bit short on time. So I know, Brett, you wanted to say that you want to kind of connect the dots to what's going on here and now with some of these questions about the Constitution. So Brett, go ahead, please.
Thank you, Dr. Gray. One of the things that we're trying to do with our classes is to lift up things in each class and connect it to what we're doing now. And so in regards to looking at this whole question about voting rights, we're using the term when we have the citizenship school, that is the Modjeska Simkins. We talk about what we want to do is to create effective citizens. And effective citizens have to know who made the rules, who benefited from them when they made them, and who benefits from them now. And the fact is that we have bad theater that passes for democracy in America in general and South Carolina in particular. And I've been running the same organization here now for 45 years, studied under Modjeska Simkins for nearly 20. And so there's this linear line of understanding that, as Dr. Burton pointed out, we're going to have to organize our way out of this problem. Greg Howell pointed out that we can't have civil justice without economic justice. And so we teach in the Modjeska School that we can't fix it with the tools that keep it broken. We now have, since 2002, a trifecta where all the government in South Carolina is controlled by the same party. This is the party that gets to make the decide who votes for whom. They draw the lines, and they're being allowed to by the Supreme Court, to protect their party's ascendancy and control. The party can draw lines for political reasons. And they do that, and they're winning. And most of us now in South Carolina, well over 75%, have only one candidate with a possible chance to win in a general election. And so we're not discouraging voting. We think everybody needs to vote. Everybody needs to raise hell. Go talk to your legislator all the time. But if that's all we do, which is basically what everybody's doing, the Democrats are going to tell you again, every vote counts, and they don't. Black votes in South Carolina now, we've done the math. The weight of a black vote today in South Carolina is about 1/3 the value, not the value, but the weight of a white vote. And that's because of the packing of black people into districts. And if you pack more people in a district, than is needed for that district to be a competitive district, then you're diminishing the strength of that vote. Our maps show two majority Black districts, or Black districts that can be won by people of color, congressional districts, and one that's challengeable. And we have our own maps that show that if you did let the computer decide, if you tell the computer, I just want most democratic stuff, you could have districts in the legislature, the 170 seats in the legislature, that would, the white folks would still be in charge because there's more of them. But what you could do is you could have the people, the population distributed in these districts in such a way as the people that run in a particular district, one of the 170, the 46 senators, the 124 House members, that the person that won that race would have to represent the interests of people that don't look or think like them. And that would be what democracy looks like, as opposed to having this, the red and blue districts. And the blues are now going to be in a permanent minority because the reds get to draw the lines. We need to keep playing the rigged game. We also have to have a longer-term strategy that has been a game in progress, I would imagine, ever since there have been people who are resisting oppression in this nation, in this country, in this world, that looks around corners. And mostly important, I think, in this time that we find ourselves, is building a sustainable community of shared values. And we organize around values because the values are common. Working people have the same values, and be talking to people about that. So that's your takeaway from the Modjeska School today, talking about voting rights, is, and I will use Audre Lorde's more eloquent statement about what we have to do. She said that we can't dismantle the master's house with the master's tools. She goes on to say that the master won't give you tools strong enough to dismantle his house or his power, but you can do some renovations. You can make the house a little nicer. Best we can do in America now, the only one of the industrial nations that doesn't have healthcare as a right, not to go on about what we don't have as rights. The best we can do now is to mitigate the damage if we keep using the tools the master gives us. So we have to figure out how to be more effective than that. Thank you for the time, Dr. Brett.
Yeah, Brett, can you spell the word? I didn't understand it, that you said we need to be.
Effective citizens.
Effective citizens. Oh, I got you. I heard it as invectus or something. Okay.
Well, we're also aggressive. But the effective citizen is something that we can't all be organizers. It's a very difficult and low-paying job. It's even worse than being an associate professor. But we can all be effective citizens and be talking to other people that share our values and figure out where would our vote be effective. We used to say that the states, the laboratories for democracy, they're not. Counties and cities can be the laboratory of democracy now. But there are enough people, and there's like 18 majority Black districts, where we can do organizing in those districts in the years to come, looking at local elections, and actually do things like taking the money out of politics on a local level, or actually do things like passing ordinances that allow people to organize and to have rights that they don't have under the right to work law. So there's various creative things that we can do if we know the tools that will work in certain places. And that's what the effectiveness we're talking about teaching people.
All right, so everyone, please give Dr. Vernon Burton a wonderful round of applause. Again, I wish we had more time, but this was, I think, a very informative session of the deeper dives of the Modjeska Simkins School. And speaking of the master's tools and such, tomorrow's Modjeska Simkins School class is going to be all about some of the forces that activists for progress and social justice have been faced with in American history in the 20th century. So we're going to be familiar with some old friends of ours, like J. Edgar Hoover, for example, and also some of how this fight looks like in South Carolina. So again, if you want to know how to make a difference in American society, one way to do that is by understanding the forces against which we are arrayed. So again, thanks to everyone for joining us this afternoon. And I hope to see the students in Modjeska School for Social Justice and Human Rights on tomorrow as well. So again, thank you, Dr. Burton, for joining us. This was a wonderful class as always. And thanks to everyone for your participation this afternoon.
Thank you, Vernon.
Thank you, Brett. We'll see you, I guess, in Nashville.
I hope so, sir.
Yeah, that's how I sort of got into the voting rights thing, having done voter registration through SOC. And